Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than 2 candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the result declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, the 4 issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the 3 petitions, number CA/PEPC 03/2023, CA/PEPC 04/2023, and CA/PEPC 05/2023 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected President of the Federal Republic of Nigeria. The parties in the 3 petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to reach his own judgment. Arrange it.
Thank you. Please sit down, sit down. Thank you, my Lord. I was privileged and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I am in full agreement with the lead judgment as delivered by him in these 3 consolidated petitions, which are petitions number CAPEC 03/2023 and CAPEC 04/2023 and CAPEC 05/2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the 3 petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers. While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is sui generis, of its own kind or class. It is not like going to court to make a claim of debt, contract, or tort. It has its own character, and it is unique by its nature. The slightest non-compliance with a procedural step, which otherwise could either be cured or waived in ordinary civil proceedings, could result in a fatal consequence to election petition. A lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition and for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule, under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall used in this legislation makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or it is difficult to prove the same petition. In the instant case, the petitioner's pleadings were deficient. While they complained of non-compliance with the Electoral Act against first respondent, their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these 3 consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read